Good morning and welcome to Legally Raven here, where today we are going to go over our second bar exam essay. So we know we read through, I believe, all the February 2021 questions, and we cannot find a good civil procedure question. And since we are going over civil procedure currently, we needed to find a civil procedure question. So what we are going to, so I'm using this new software called Bar Exam Drills. And Bar Exam Drills really uses this 5-layer approach to writing a bar exam essay. And so I am using the California July 2016 bar exam essay on civil procedure. So what it does is it takes you through all the different fact patterns and helps you draw conclusions and really kind of gives you a good outline to your essay so you can make sure that you spot any issues and the rule that applies. So I did it on the app first on my phone to get everything in my mind, and then I took that information and wrote this essay. So we will do a video where we show exactly how it works, but that's just an overview. So let's go ahead now and look at the California 2016 bar exam essay civil procedure question. Paul, a citizen of Mexico, was attending college in San Diego on a student visa. He drove to San Francisco to attend a music festival. While he was there, he bought and ate a bag of snacks from Valerie, a resident of San Francisco. The snacks had been manufactured in Germany by Meyer Corp, a German corporation with its sole place of business in Germany. The snacks contained a toxic substance and sickened Paul, who incurred medical expenses in the amount of $50,000. Paul filed an action pro se against Valerie and Meyer Corporation in the Superior Court of California in San Diego. In his complaint, he alleged that Valerie and Meyer Corp should have known the snacks were contaminated and demanded $50,000 in compensatory charges. Paul drove to San Francisco, where he personally handed Valerie a summons and a copy of the complaint. He sent a summons and copy of complaint to Meyer Corp by ordinary mail to the company, and a copy of the complaint to Meyer Corp by ordinary mail to the company in Germany. Okay, right. All right, so now the essay had 4 questions. Some of them have A and B parts, so we are going to answer them through the essay. So essay answer. Paul, a citizen of Mexico, temporarily living in San Diego, California on a student visa, drove to San Francisco to attend a music festival. At the music festival, Paul purchased and consumed a bag of snacks from Valerie, a resident of San Francisco, California. Valerie was the retailer of the snacks, but they were made in Germany by Meyer Corp, a German company that is both incorporated and operates exclusively in Germany. Meyer Corporation has no corporate presence in the United States. Paul and no corporate presence does not conduct any business in the United States. Paul ate the snacks. The snacks contained a toxic substance that made Paul sick. Paul's medical bills for treatment related to eating the snacks were $50,000. Paul filed a lawsuit pro se or without an attorney against Valerie. And Meyer Corp in the Superior Court of California in San Diego. Paul filed a lawsuit in the Superior Court close to where he attends college in San Diego, rather in San Francisco, where Valerie resides. Number 1, did Paul Valerie serve the summons on Valerie? Discuss it. Paul drove to San Francisco and personally handed Valerie a summons and a copy of the complaint. According to the Federal Rules of Civil Procedure, Rule 4, Section C, Part 1, Paul was correct in serving the summons with the complaint. However, Paul erred in delivering the summons himself. The Federal Rules of Civil Procedure 4C2 explains that service of the summons may be done by a person who is at least 18 years old and is not a party to the complaint. As the plaintiff in this case, the FRCP does not allow Paul to serve the summons, so Paul did not validly serve the summons to Valerie. Did Paul validly serve the summons on Meyer Corp? Explain. Paul did not travel to Germany to serve the summons to Meyer Corp. Instead, he sent the summons to the company in Germany by ordinary mail. sent the summons and complaint to the company in Germany by ordinary mail. The FRCP Rule 4, Section F says unless federal law provides otherwise, an individual other than a minor or incompetent person or a person whose waiver has been filed may be served at a place that within the judicial district of the United States. So it's okay to serve somebody outside of the United States. Meyer is not a minor, incompetent, and has not filed a waiver, so they can be served in Germany. But both Germany and the United States are signatories in the Hague Service Convention. They are not required to use it as the only method of service. According to Federal Reserve Civil Procedure Rule 4, Section F2C, to using any form of mail that the clerk addresses and sends to the individual and requires a signed receipt, or 3, by means not prohibited by international agreement, as in the court orders. Without further information regarding a specific agreement between the U.S. and Germany and the fact pattern of the essay, it is assumed that Paul's service of the summons on Meyer by ordinary mail is not valid. Does the Superior Court of California and San Diego have personal jurisdiction over Valerie? Discuss. The 58 Superior Courts in California are the state trial courts with general jurisdiction to hear and decide any civil or criminal action not specifically designated to be heard in some other court or governmental agency. There is a court in each county in San Diego, California. In general, all California Superior Courts have personal jurisdiction over a person that lives in California or can be found in California, and for a business or organization where a business or organization conduct business that conducts business in California. Valerie lives in San Francisco, California. Paul did not need to file his lawsuit in the Superior Court of San Francisco, for the courts have personal jurisdiction. All Superior Courts in California, including the San Diego Superior Court, have personal jurisdiction over Valerie, a resident of California. Does the Superior Court of California and San Diego have personal jurisdiction over Meyer Corp? Discuss. Meyer Corporation is incorporated in Germany and does business exclusively in Germany and will serve summons in Valerie in Germany. California's firearm statute requires a non-resident defendant that was not served their summons and complaint in the state to have minimum contacts within the state to establish personal jurisdiction. Meyer has no contacts with California, so the test of minimum contacts is not met, nor is Meyer consented to personal jurisdiction. Was not served, nor has Meyer consented to personal jurisdiction. Therefore, the Superior Court of California and San Diego does not have personal jurisdiction over Meyer Court. I'm just going to pause it for a minute because I forgot to answer part of the question. This venue properly lies with the Superior Court of California and San Diego. Explain or discuss. Jurisdiction covers in what state a lawsuit can be filed, whereas venue in California is the county where the action should be filed. The venue is the county where the plaintiff lives or does business. The plaintiff lives. Venue in California is the county where the action should be filed. The venue is the county where the plaintiff lives or does business. In addition, and also be established where the cause of action arose. Valerie lives in San Francisco, and Myra Corporation operates exclusively in Germany. The cause of action, the cause of action happened in San Francisco. I was visiting San Francisco for a music festival and a contaminated snack, and, and ate the contaminated snacks in San Francisco. In conclusion, Lean does not properly lie in Superior Court of California in San Diego. Is cause action properly removable to federal court discussed? Removal to federal court requires that the lawsuit is about a federal question or diversity of citizenship exists between the plaintiff and all the defendants, and the amount in controversy is greater than $75,000. There is complete diversity of citizenship because Paul is not domiciled in California. Paul is a citizen of Mexico. Valerie is the domiciliary of California, and Michael is a citizen of Germany. There is a two-part requirement for removal to federal court based on diversity. The amount of controversy must be greater than $75,000. Cause action is not properly removable to federal court because even though there is complete diversity of citizenship, the amount of controversy is only $50,000. $50,000 is below the federal court remove the threshold amount of controversy of $75,000. And that is the end of our essay. Thank you very much for tuning in to today's episode of the Legally Great